In this video, we'll discuss regarding those questions from 25 to 35 and almost all these questions are relating to those writs like habeas corpus, certiorari, prohibition, mandamus, and Quo-Waranto. So, as regarding question number 25 and 26, under what conditions the very writ of habeas corpus is issued and under what circumstances the writ of habeas corpus is refused. So, the grounds for issuing a writ of habeas corpus are that the applicant must be in custody and the applicant for the grant of writ of habeas corpus must be by the near relative of the detainee, such as his wife or father or son or mother, etc. And a few years back, the application for the issue of writ could not be given by any stranger. But after the Supreme Court decision in Sunil Batra versus Delhi administration in 1980, the very view was changed. So any person can file a writ of habeas corpus. And in another leading case, so also in Mrs. Bina Sethi versus State of Bihar in 1983, the Supreme Court held further that even a postcard written by a detainee from jail or by some other person on his behalf, inspired by social objectives, could be taken as writ petition. And regarding the third ground, that is, all the formalities relating to arrest and detention must be complied with and it must not be made malified or for collateral purpose. So, in the leading case, Amar Singh versus Crown in 1949, the Punjab High Court held that when a magistrate did not report the arrest to the government of the province as was required by Section 3, Clause 2 of Punjab Public Safety Act 1947, the detention was held illegal. So, another ground of another ground of filing the very petition of habeas corpus is that the order of detention should be defective in substance. For example, misdescription of detainee, failure to mention place of detention, etc. A warrant which directs the committal of such, and if it is not without any description of such person, is invalid since it may lead to the detainee arrest of and any person. So, hence complete description of the detainee should be given in the order of detention. And the fifth condition requires for a writ of habeas corpus to be filed, a malified order will be a ground for relief. It was so observed by Justice Rajgopalan in matter of N.R. Srinivasan in 1945 by the Madras High Court, whether malafide or not could be inferred from the long delay in communicating the detention order to the government, was discussed by Justice Subba Rao in Venkata Mani versus Commissioner of Police Madras. So also it is well known case of Ram Narayan Singh versus State of Delhi in 1953. The petitioner alleged that they had been detained because they were members of the Hindu Mahasabha, a political organization opposed to the ideals or policies of the party in power. The Supreme Court held that allegation and malafide conduct were easy to make but not always easy to prove. So the burden lay on the petitioners to prove that the district magistrate acted malafide in issuing the order of detention, and the sixth ground for issuance of a writ of habeas corpus is that it must be established that the detaining authority was not satisfied that the detainee was committing prejudicial act, etc. It may be noted in this connection that sufficiency of the material on which the satisfaction is based cannot be subject of scrutiny by the court, and the next ground is that vague and indefinite grounds of detention will entitle the petitioner for relief, and so delay in furnishing grounds may entitle the detainee to be released. So also where the order of detention is irregular, and lastly where the detention is for activities outside the provinces. So these are the very conditions or grounds required for to file a writ of habeas corpus under Article 32 of the Constitution or Article 226 of the Constitution for filing a writ of habeas corpus in high courts, and regarding the very refusal of a writ petition relating to habeas corpus, those grounds, the writ of habeas corpus, as you know, can be issued by High Court under Article 226 only if the person or authority against whom the writ is sought is within the territorial jurisdiction of the High Court. So a writ of habeas corpus cannot be issued in the following cases: where the prisoner is detained in a place outside the jurisdiction of the High Court to which the application is made. So also where there is no occasion of habeas corpus unless the petitioner is in custody or detention, and where the effect of granting the writ would be to review the judgment of a court which is open to appeal, or to verify the record of a court which shows jurisdiction on its face. So a rule for habeas corpus must be discharged when the petitioner has been released by the person or authority who had kept him in detention. So, on the same principle where during the pendency of an appeal against the order refusing an application for habeas corpus, the applicant is released from custody. The appeal must be dismissed and the appellate court cannot be asked to pronounce the correctness of the judgment by which habeas corpus have been refused. So these are the grounds of admitting a writ of habeas corpus, also the grounds of refusing the very petition of habeas corpus. And now we'll discuss the very writ of certiorari and in which cases it could be filed. The writ of certiorari can be issued on the following grounds: where there is lack of jurisdiction or excess of jurisdiction or abuse of jurisdiction or violation of the principle of natural justice or error of law apparent on the face of record, so also on the grounds of fraud. So these are the grounds under which the writ of certiorari could be issued, and all those grounds as relating to excess jurisdiction or lack of jurisdiction and violation of the principle of natural justice, abuse of jurisdiction, and regarding that we will discuss certain leading cases in relation to that. So regarding lack of jurisdiction, the very important leading case relates to that. Buddha Prakash versus STO in 1952, Allahabad High Court illustrates lack of jurisdiction where subject matter is outside its scope, as the fact the sales tax officer exercising powers under the UP Sales Tax Act imposed tax on forward contracts irrespective of the place where delivery took place. The court issued certiorari on the ground that the subject matter is outside the jurisdiction of the authority. So regarding excess jurisdiction, we could discuss the leading case J.K. Chowdhury versus Datta Gupta. In 1958, the Supreme Court is typical illustration on the subject. So in this case, the governing body of a college affiliated to the Guwahati University dismissed its principal, Mr. Datta Gupta, on the ground of misconduct. The Executive Committee of Guwahati University, after having representation order reinstatement, the court issued certiorari to quash the decision on the ground of excess of jurisdiction, because the jurisdiction of the university under section 21 subsection 9 of the Guwahati University Act was confined to teachers and did not extend to a case where the person holds the office of principal. So regarding abuse of jurisdiction, we will discuss the important leading case Purtapur Company Limited versus Ken Commissioner of Bihar in 1969. The Supreme Court, regarding this leading case, the Ken Commissioner, who had the power to reserve sugar vacant areas for the respective sugar factories at the dictation of the Chief Minister, excluded 99 villages from the area reserved by him in favor of the appellate land company. The court quashed the exercise of discretion by the Kane Commissioner on the ground that he abdicated his power by exercising it at the dictation of some other authority. Therefore, it was deemed that the authority had not exercised its discretion at all, and regarding violation of the principle of natural justice also, certiorari could be issued, and regarding that, if there is the very violation of the principle of natural justice regarding rule against bias, which constitutes personal bias, pecuniary bias, subject matter bias, departmental bias, and preconceived notion bias, also the very rule of odi alterum patum, which consists right to know adverse evidence, right to present case, and right to rebut evidence, and right to cross examination and legal representation, right to reasonable decision. So, under these grounds also, the very writ of certiorari can be issued, and as regarding the very issuance of certiorari as the grounds of refusal of the certiorari, so that we will discuss on the condition that all these grounds that we have discussed, if these grounds are not found on the very writ of filing a certiorari, it could be refused. And now we'll go to the very writ of mandamus, and as actually in the very writ of mandamus, what conditions are required for issue of the writ of mandamus. So, the condition, there must be a public duty, and that public duty is done which is created either by a statute or the constitution or by some rule of common law, as it was decided by the Supreme Court in Commissioner of Police versus Gordon Das in 1952. So also the public duty enforceable through mandamus must also be an absolute duty. Absolute is one which is mandatory and not discretionary, as it was decided in the leading case, Manjula Manjari versus Director of Public Instruction in 1952 by the Odisha High Court. So also, mandamus would also lie to compel the authority to refuse the amount of fee it has collected under law, which has been declared ultra virus by the competent court, as it was decided in Shiv Shankar Dal Mills versus State of Haryana in 1980 by the Supreme Court, and the very condition relating to issuance of the writ of mandamus, there must be a specific demand and refusal. And regarding that, exactly it means before mandamus can be granted, there must be a specific demand for the fulfillment of duty, and there must be specific refusal by the authority. So, another condition for issuance of the writ of mandamus is required that there must be a clear right to enforce the duty. So, mandamus cannot be issued unless there is in the applicant a right to compel the performance of some duty cast on the authority. Therefore, in the leading case, SP Manucha versus State of Madhya Pradesh in 1973, Madhya Pradesh High Court refused to issue mandamus to the college to admit the petitioner because the petitioner could not establish clear right to admission in college, and regarding the grounds of issue of mandamus, in brief we can say that the petitioner has a legal right and that there has been an infringement of the legal right of the petitioner. So this infringement has been owing to non-performance of the corresponding duty by the public authority, and so also that the petitioner has demanded the performance of legal duty by the public authority, and the authority has refused to act, so that there has been no effective and alternative legal remedy. So this may be subdivided as follows. The writ of mandamus is available against all kinds of administrative action if it is affected with illegality. So also where some mandatory duty, including the duty to decide in each case whether or not an occasion has arisen for the exercise of the power, is imposed on public authority. So also where the public authority exerts the power, the protection of human liberty and property is the sacred duty of the state. So also where there is an exercise of discretion in an unlawful manner, generally the court does not issue the writ of mandamus where there is only exercise of discretionary power of administrative authority. But the court will interfere if there has been an illegal exercise of discretion. So, also, the very circumstance that in the case of abuse of power, so these are the grounds for issuance of a writ of mandamus. So also it can be refused, and having certain grounds such as the leading case Supreme Court held in Daya versus Joint Chief Controller in 1962 that where the act against which mandamus is sought has been completed and the writ is, if issued, will be infructuous. On the same principle, the court could refuse a writ of mandamus where it would be meaningless owing to lapse of time or otherwise. In the same way, Calcutta High Court has held in EI Commercial Company versus the collector in 1957 that where the application is premature, for instance, where no action contrary to law has yet been done or proposed, the writ may be refused. So a mandamus will not issue when it appears that it would be futile in its results. So also, the Nagpur High Court has held in Ibrahim versus Commissioner in 1951. The Nagpur High Court held that the writ being discretionary, it may be refused on the equitable grounds such as suppression or misstatement of material facts in the application. So the writ of mandamus may be refused on the grounds of laches or unexplained delay. And as Supreme Court has held in Sonlal versus Union of India in 1958 that mandamus is not an appropriate proceeding to decide questions of title to property or complicated questions of fact. So mandamus cannot be issued against public servant to enforce a contract independently of any statutory duty or obligation to the applicant. So also the Nagpur High Court has held that mandamus will not be issued to compel a person to institute legal proceedings even in cases of contravention of a statute. And Supreme Court has held in Vice Chancellor versus S.K. Ghosh in 1954 that the object of mandamus being simply to compel performance of a legal duty on the part of some person or body who is entrusted by law with that duty. The court in a proceeding for mandamus will never sit as a court of appeal so as to examine facts or to substitute its own wisdom for the discretion vested by law in the person or body against whom the writ is sought. So also writ of mandamus would not issue to correct a mere irregularity which has not affected the jurisdiction or resulted in a failure of justice. So these are the different grounds under which the very relief required in filing the writ of mandamus can be refused, and as to the writ of prohibition, so the very grounds of the writ of prohibition could be issued as to lack of jurisdiction, violation of the principle of natural justice, infringement of the fundamental rights, fraud, and contravention of the law of the land. So, the very question relating to filing those writs of habeas corpus, certiorari, mandamus, and prohibition, the very grounds of admitting a writ petition of those writs and the very grounds of refusal of admitting such a writ petition are, as we found, as decided by the different high courts and supreme courts. So in our upcoming video we'll discuss the last writ, that is relating to writ of Quo-Waranto.